The European insolvency. Insolvency was one of the subject matters excluded from the scope of the Brussels I regulation. Nevertheless, it was recognized that there was a great need for a European instrument providing for the possibility for an order in matters in insolvency law to be recognized and enforced in all the member states, and which was neither restricted in application by the borders of member states nor by their national procedures, very varied as they are. The activities of business undertakings have more and more international as well as cross-border effects as a result of the development of the internal market. In addition, it was necessary to seek to remove any incentives for business undertakings to transfer assets from one member state to another in an attempt to defeat the interests of creditors and to seek to obtain a more favorable legal position. Furthermore, the proper functioning of the internal market requires that cross-border insolvency proceedings in the European Union should operate efficiently and effectively. Objectives of this nature obviously could not be achieved to a sufficient degree at the level of the member states, thus rendering it necessary for provisions on jurisdiction, recognition, and applicable law in insolvency to be expressed in a measure in European law. Negotiations to this end were commenced between the member states in the early 1990s following the entry into force of the Maastricht Treaty and concluded with the adoption on November 23, 1995, of the text of an international convention among the then member states. This convention never entered into force, but was effectively the basis for the subsequent regulation adopted on May 29, 2000. The European Insolvency Regulation contains provisions for the regulation of the interaction of insolvency proceedings between member states of the EU. The regulation entered into force on May 31, 2002, and applies to all proceedings opened after this date. 1. Scope of the EU Insolvency Regulation. The Insolvency Regulation applies to collective insolvency proceedings, whether the debtor is a natural person or a legal person, a trader, or an individual in which the debtor is divested of property in whole or in part, and the liquidator or administrator is appointed in relation to the debtor. The proceedings concerned are defined by article of the regulation and listed specifically in Annexes A and B thereto. In order for the insolvency regulation to apply, proceedings must be officially introduced and legally effective in the member state where they are opened. 2. Jurisdiction rules in the regulation. Article 3. The regulation contains rules of jurisdiction to establish which court in which member state is competent to open and conduct insolvency proceedings. It is based on the principle that there should in the EU be only one procedure in relation to the insolvency of a particular debtor. This should consist of main proceedings with universal scope and eventual further secondary proceedings. The competence for the opening of the main proceedings should lie with the courts in the member state within the territory of which the center of the debtor's main interests is situated. National proceedings covering only assets situated in the state of their opening, referred to as secondary proceedings, are allowed alongside the main proceedings. In the situation where national proceedings are opened before the main proceedings, they are called territorial proceedings and continue until the main proceedings are opened. 3. Main, secondary, and territorial insolvency proceedings. Main insolvency proceedings and secondary proceedings are conducted separately and usually by different liquidators. They can, however, contribute to and result in the effective realization of the total assets only if all the concurrent proceedings pending are coordinated. In order for that to happen, the various liquidators must cooperate closely, in particular by exchanging a sufficient amount of information about the progress of the respective proceedings. The liquidators are to communicate, amongst other information, the lodging and verifying of claims, as well as measures aimed at terminating the proceedings. In order to ensure the dominant role of the main insolvency proceedings, the liquidator in such proceedings is given several possibilities for intervening in secondary proceedings, which are pending at the same time. 4. Creditors. Every creditor who has their habitual residence, domicile, or registered office in a member state has the right to lodge their claims in each of the insolvency proceedings pending in a member state relating to the debtor's assets. However, in order to ensure equal treatment of creditors, the distribution of proceeds must be coordinated. Every creditor can keep what they have received in the course of insolvency proceedings, but is entitled only to participate in distribution of total assets in other proceedings if creditors with the same standing have obtained the same proportion of their claims. Whether and on what conditions a creditor is admitted to request the opening of secondary proceedings is determined by the law of the member state within the territory of which these proceedings are opened. Similarly, the effects of such proceeding are restricted to the assets of the debtor which are situated within the territory of the member state where the secondary proceedings take place. 5. Applicable law and insolvency proceedings. Article 4. According to the principle contained in Article 4 of the Insolvency Regulation, the law applicable to insolvency proceedings and their effects is that of the member state within the territory of which such proceedings are opened. The lex concursus determines all the effects of the insolvency proceedings, both procedural and substantive, on the persons and legal relations concerned. The regulation furthermore sets out, for the matters covered by it, uniform rules on conflict of laws which replace, within their scope of application, national rules of private international law. Provision is made for special rules on applicable law in the case of particularly significant rights and legal relationships, such as rights in rem, set-off, reservation of title, and contracts of employment. These exceptions to the general rule are provided to protect the legitimate expectations of creditors and the certainty of transactions in member states other than that in which proceedings are opened. 6. Recognition of insolvency proceedings. The regulation provides for immediate recognition of judgments concerning the opening, conduct, and closure of insolvency proceedings which come within its scope and of judgments handed down in direct connection with such insolvency proceedings. As a rule, the judgment opening insolvency proceedings shall be recognized in all member states from the time that it becomes effective in the state of opening. It will produce, with no further formalities, the same effects in other member states as under the law of the state of opening, unless the recognition would be manifestly contrary to the public policy of a state. Furthermore, the appointment of the liquidator and his powers, as conferred by the law of the state of opening, will be fully recognized in other member states. 7. The proposed reform of the insolvency regulation. The European Commission published a proposal for reforming the insolvency regulation on the same day as the report of December 12, 2012 on the application of Council Regulation number 1346/2000 of May 29, 2000 on insolvency proceedings. Negotiations on this proposal are currently in their final stages. The reform will essentially consist of the following elements: scope, extension of the scope of the regulation by revising the definition of insolvency proceedings to include hybrid and pre-insolvency proceedings, as well as debt discharge proceedings and other insolvency proceedings for natural persons which currently do not fit the definition. These amendments, if adopted, would also bring the regulation more into line with the approach taken by the UN Citral Model Law on cross-border insolvency. Jurisdiction. Clarification of the jurisdiction rules, notably by complementing the definition of the concept of the Center of Main Interest, COMI, and also by improving the procedural framework for determining jurisdiction by requiring courts and liquidators to examine the jurisdictional grounds for an insolvency proceeding. Secondary proceedings. Provisions enabling more efficient administration of insolvency proceedings by enabling the court to refuse the opening of secondary proceedings if certain conditions are met, in particular, if this is not necessary to protect the interests of local creditors, by abolishing the requirement that secondary proceedings must be winding up proceedings, and by improving the cooperation between main and secondary proceedings, in particular, by extending the cooperation requirements to the courts involved. Publicity of proceedings and lodging of claims. Requirement for member states to publish relevant court decisions in cross-border insolvency cases in a publicly accessible electronic register, and for the interconnection of national insolvency registers. Groups of companies, creation of a legal framework for the treatment of the insolvency concerning different members of the same group of companies, in particular by introducing a group coordination procedure and by obliging the liquidators and courts involved in the different main proceedings to cooperate and communicate with each other.